waiting for the rest, for it to become actually officially 9 o'clock according to MIT time. If you could take a couple of minutes to fill out the thing in the meantime, I'd really appreciate it. Has everybody got one? Passed it around? Based on your feedback yesterday, I want to let you know that I sort of rearranged things already. I think as Tom said that, you know, everybody has a plan until the first shot is fired and all the plans go out the window. So while I had a curriculum sort of laid out in my mind, based upon our discussion yesterday, which I think obviously was weighted very heavily in favor of material science, but also I sensed, and please correct me if I'm wrong, that there was interest in getting into intellectual property right off the bat. That seemed to be something that you folks would really like to get into. So starting next week, we'll be getting right into the introduction to intellectual property. We'll be covering all the things that we discussed yesterday: trademarks, copyrights, patents, fair use, misappropriation of intellectual property, all the things that I think that probably you should be conversant with when you walk out that door with your diploma, at least as to intellectual property and how you protect it and need to respect it. And that will cover next Thursday and Friday, the following Thursday and Friday, and the following Thursday and Friday. I want to cover the subject at your pace. I don't want to get too bogged down in trivia and detail. And I also want to schedule those experts that I talked about so that you can come in and dissect them. And as I said, for perhaps the only time in your life, sit down in front of a lawyer that charges $750 an hour and not have to pay him anything for your questions. So as I can schedule those folks, work them into the calendar, I will. But next week starts intellectual property. Today, what we're going to talk about is really one of the founding principles of intellectual property. You can't get to intellectual property until you cover what we're going to cover today, and that is free speech and the foundations of free speech. And I wanted to introduce the subject to you again. I know I'm standing in front of a bunch of engineers and material scientists here, so and not law students. And so I try to make this subject area relevant to your lives. And the way it's relevant to yours is really no different than the way it's relevant to other people's lives, at least as far as the principles are involved, are concerned. And so I wanted to take up the case, the sad and odd case of Charles Marone. Did everybody get a copy of the handout last night about Charles Marone, that poor unfortunate engineer in Minnesota who made the mistake of opening his mouth and exercising his right of free speech? Because when I saw that come across my radar screen earlier this week, talk about plans being set aside, I had one sort of lecture planned for you guys on the fundamental principles involved in free speech. But when I saw this guy's letter come across my radar screen, I said to myself, thank you. I mean, what's probably bad for Charles Marone is good for me and good for you guys, because I thought this was a perfect example of how to illustrate the concepts, the fundamental concepts of free speech to a bunch of future engineers and material scientists. As you know, Charles Marone was an engineer out in Minnesota who one day opened up his mail, and after he looked at the Comcast bill and the Macy's bill, got this letter from the Board of Registration for Professional Engineers. Does everybody know what a Board of Registration is for professional engineers? You know, when you practice engineering, and by the way, it's the same for architects, tattoo artists, doctors, veterinarians, and every state in which you practice, has a board of registration. Whether it has to do with engineering or something else, you're going to end up dealing with a board of registration in some professional service. So anyhow, poor Charles gets this letter in the mail saying, the board's complaint committee needs to inform you that a complaint was received against you, filed by Jeffrey Patola on January 5th, 2015. The complaint alleges violations of Minnesota statutes 326111, subdivision 4A1, 4, 2014, and Minnesota rules, yada, yada, yada. Your file was assigned to a committee member who reviewed the complaint and presented it to the complaint committee. Based upon the information in the complaint, the committee determined there was no violation and no further investigation was required. Accordingly, the file referenced above has been closed and it has been identified as having no violation. Please note, however, that the complaint will be held in the board's archives and is available should additional evidence warrant that the file be reopened. If you have any questions, please contact your friendly investigator. What if you get it? What if you get that in the mail? What are you thinking? If you're Charles, what are you thinking?
What did I do wrong?
Exactly. And where does it say where does it tell you what you did wrong in here? It doesn't tell you what you did wrong in here, does it? What else are you thinking? Aren't you thinking that whatever I did wrong, if I ever do it again, they're going to pull my license? How does that make you feel as an engineer? How does it make you feel as a person?
Insecure.
Very insecure. Why?
I expect you might be good if you like.
They're talking about pulling your ticket. No ticket, no paycheck. And that's what they call, that's what lawyers call, deprivation of property. Okay? They're going to pull your ticket, you're not going to be able to earn a living. The other thing that's involved here, which you put your finger on, is due process of law. Everyone has a right to know or to be put on notice about exactly what it was that they did, which supposedly constitutes the violation of the professional standard. Where does it say in this letter facts? Where does it give facts which allow poor Charles to know what it was that he did to violate all these codes with fancy numbers next to them? As you point out, there's nothing in there, and that's what leads to the insecurity. How does somebody defend themselves against something like that? Well, the background of the case is that Charles was an avid blogger, and the complaint, as we already went over, indicated that he'd engaged in misconduct on the website Blog Strong Towns for things he has written of the engineering profession. Apparently what Charles did is he called his friendly neighborhood complaint investigator, and he did get the file, which puts him ahead of most people who try to get their files from professional organizations. When they hire a guy like me, that's the first thing we try to do, and oftentimes we can't get it. Anyhow, what happened in this particular case is somebody took offense at something that Charles had written on a blog about the way Minnesota engineers have supported the public policy regarding the construction of roads and maintenance of infrastructure. And that's something that you as material scientists, or something that you as material scientists are likely to encounter. You know, what if you're involved in a project and you find, based on your judgment, in your conscience, that the specs for that particular job are not adequate, and maybe one of your superiors has signed off on it already? What do you do? Do you have a right to speak out about it? Do you have a right to have an opinion and voice that opinion in a public forum, as Charles has? Sometimes, you know, the only way to get attention to things like this is to make your voice heard in a public forum. You may go to your supervisor and say, I think there's something wrong with this project, this material, or this method, or this process. And they say, there, don't worry about it. Then what do? What if you can't go to bed at night thinking that you haven't done everything possible to promote public safety and public welfare? What if you feel like the people above you are not answering that responsibility? Do you have a right then to go and speak in a public forum? What if you do? Will you lose your job? Will you have your professional license revoked? Anyhow, it was filed by the former American Society of Civil Engineers fellow who is currently an outspoken member of the Move Minnesota Coalition, an organization advocating for more transportation funding in Charles's home state. It was filed on the day that poor Charles wrote a blog post being critical of that. Now, the effort to take away Charles's professional license for speaking out is, in a word, appalling. But it isn't surprising. The reasons are, he's long opposed the American Society of Civil Engineers. This society feels that you should not speak out against it. The view on how our country should be developed are stunningly radical in their view. You know, especially as young people, I think you'll find at some point in your career that there's a true divergence of opinion between older, experienced engineers and younger ones who are just coming into the profession. And that's apparently what has happened in this case. There's sort of an establishment in Minnesota, and Charles is sort of not walking in lockstep with them. And that establishment took offense to it and has decided that they need to investigate this. He's been an outspoken of the Move Minnesota Coalition and their version of success. He's told privately that he's not a real engineer. Imagine someone coming up to you saying, because you won't toe the line, you're not a real engineer. Because he didn't support more funding for expanding the current system. And most importantly, he's been critical of how the engineering profession approaches safety within the cities. He pointed out that the industry's standard approach for over-engineering America's roads and suburban streets is as if they were high-speed, high-capacity roads is no longer appropriate given the density of the environment in which these roads exist. And the current variant of engineering, of the engineering profession, gained prominence in an area of enormous highway construction and expansion. But that knowledge does not apply to complex places like downtown Boston. Bottom line, he declared that today our urban streets are not safe for everyone, whether in a car, a bike, a wheelchair, or simply walking. But that's not acceptable. So the question's raised, should he be allowed to be an engineer? Do we have, apparently somebody thought Charles's license should be revoked, should be pulled. So obviously, I think everybody in this room probably thinks he should be an engineer. What do you say to the people that think he shouldn't be an engineer? Anybody? What do you say to them? Can a licensed engineer oppose new construction and still retain his professional license? Can a licensed engineer question the appalling safety record resulting from standard industry practices and be allowed to remain in the industry? What do you think about people having to, engineers, do you think you have, as an engineer, a responsibility to speak out against safety concerns that you see?
I think you probably have a responsibility as an engineer to do it. I mean, you look at like the Morton fire call, Challenger incident.
What a great example.
That engineer had a responsibility, like an ethical responsibility as an engineer to voice his concerns. They didn't necessarily care what he said, but in the end, that's what led to him being able to keep his job, like further down the line, whereas before he would probably be in prison.
A better example I couldn't possibly think of, the Morton fire call, the O-rings. And there's a person that had enormous pressure to keep their mouth shut. And you as material scientists and engineers are likely to run into one of these problems at some point in your career. Did that person have a right to speak out publicly? Do they have a right to voice those opinions, those concerns in a public forum? I know he tried to voice those concerns in the chain of command. What if he decided to open up a blog post and say, look, no one's listening to me. These O-rings are a danger. Could he be dismissed for that? Should he be dismissed for that? The answer is he could be dismissed for that. And probably shouldn't be dismissed, but the answer is he could be dismissed for that. Now, the Minnesota statute raises some doubt about whether or not he has a right to engage in this behavior. Because the Minnesota statute has this little phrase in it, or this section that says, a licensee shall avoid any act which may diminish public confidence in the profession and shall at all times conduct himself or herself in all relations with clients and the public so as to maintain its reputation for professional integrity. What does that mean? Can anybody in the room tell me what that means?
It seems like what it's trying to say is that basically you're gonna maintain your standards throughout your engineering practice and not do something so as the public questions your abilities as an engineer or engineers in general.
That's certainly one interpretation. I have to tell you myself, I have no idea what that means. I think that means whatever you want it to mean. And this is the type of standard which you may find yourself hoist on at some point, as poor Charles did. Because I really have no idea what that means. What does it mean, any act that may diminish public confidence? Is that talking about safety problems? Is that criticizing the other engineers? Is that criticizing public policy? Or do you have a right to do that, even if it does diminish your reputation? What do you think? Anyhow.
There's a question up here.
Oh, I'm sorry.
I mean, I would argue that the counterpoint, I don't think it's necessarily diminishing public confidence by speaking out about something that's wrong with the public interactions. I would argue it's enforcing and reinforcing public confidence. That if you have an honest broker who's going to inform the public about what's safe and what's not, I would argue that the counterpoint that he is actually, by doing that, is in fact following this.
I'm with you.
But I think for someone who's in the public, they would, if you're seeing one engineer speaking out against 10 who want to build new roads, like, yes, maybe we all see that like the one is right, but like the public, who you're listening to, 10 people who are all like pushing new roads, or one guy who's speaking up, like, if the public doesn't know who to listen to, that's what I think this is afraid of.
I think you may be right about that. Yes?
That just seems incredibly problematic because the person can decide it for themselves. Like the person who's speaking out is going to say, I'm increasing public confidence, and then the other 9 people are going to be saying the same thing on the other side.
I love that phrase. Do you want to come up here and I'll sit down there? Inherently problematic. That's exactly what it is. It's inherently problematic. What a great phrase. But that's what it is, I think. As a lawyer, that's what I see. I see inherently problematic. And I think that's what Charles saw. Inherently problematic. How does this define it? Do you have a point? I thought you had your hand up. I'm sorry.
No, I was just going to say there's a difference between public awareness and public confidence. I don't think he thought he was increasing public confidence by his blog. I think it was public awareness. So I think there's a difference there.
And of course, this is what the Minnesota Professional Responsibility Board seized on in order to justify their investigation. So I thought, hey, why not?
I do want to make.
I'm sorry, Tom.
The problem with that statement that you had up there is somehow the engineer is supposed to figure out what other people think before he says something. How can I know what's in someone else's mind? How can I control my actions based on what someone else might think?
I would call that inherently problematic. A very smart person I met one time. And I think that that's true. I think that's exactly right. Put yourself in Charles's position. What do you do when you get a letter like that? How do I defend myself against that?
Could Charles then do the exact same thing to whoever this other guy was, Jeffrey, whatever? Because if he's citing the safety record and the fact that people have been adhering to this code for X amount of years and it has this apparent, like this problem with the safety record, then could he use this exact same phrase to turn around and say, you've obeyed this code and you diminish the public's confidence in the engineering profession by obeying this code without thinking about it?
Wouldn't retaliation be a violation of that code? So does Charles even have a right to retaliate against his accuser and say, wait a minute, I'm not violating this code, you are violating this code. But if he does that, isn't he violating the code by diminishing the confidence and the high standards of the profession? The answer is, it's inherently problematic, and I don't know, but it depends. You know, these boards consists of, right, think of law school. Think of when you graduate law school, there's a whole bunch of people in the class that pass the bar on the first test. And there's some people that there's one guy, I think, in California that I think took it 55 times and was never able. Well, do you know where those guys, those folks go? They go and sit as judges on administrative boards. And I'm not kidding. I've represented professionals in front of these administrative boards. And you want to almost check to see if they have a license to practice law. And those are the people who are doing all the interpreting for you. And I wouldn't say that unless I've not been personally frustrated several times standing up in front of the Board of Registration in Massachusetts on behalf of some professional who's been accused of violating exactly that. There's one that I represented who was against drugs in horse racing, and who had all of their patients ran in Kentucky. They're very famous orthopedic surgeon for expensive bracelets, vehemently against drugs in horse racing. And that person, unfortunately, was on the receiving end of a complaint like this that costs $500,000 to litigate, and ultimately have them found completely exonerated. But because some very powerful people within the profession took exception to the fact that they were challenging their right to dope horses and build big houses in Newton based upon the illegal doping of horses, she had to stand up in front of the board, hire a guy like me, and defend herself. And it took 4 years. So she was fully and finally exonerated. But that's exactly the same type of language that she was faced with. But you say that can only happen in Minnesota. Massachusetts is different, right? Well, here's the Massachusetts Code of Conduct for Engineers. Have a quick look at it. The registrant shall hold paramount the health, property, and welfare of the public in the performance of the registrant's professional duties. Sounds pretty good. If the professional judgment of any registrant is overruled under circumstances where the health, property, or welfare of the public may be endangered, that registrant shall notify the registrant's employer, client, or such other authority as may be appropriate. Sounds pretty good. A registrant shall provide professional services that are truthful, based upon independent professional judgment, founded upon adequate knowledge of the issues, and based upon competence in the subject matter. Again, sounds pretty good. Sounds like some enlightened people were writing the Massachusetts Code. A registrant shall approve, sign, or seal only those instruments of service that conform to 250 CMR and generally accepted engineering and land surveying practice. Do you think there could be any disagreement over this part?
Just the last bullet?
Yeah, the last bullet. And generally accepted engineering and land surveying standards. By the way, the Code for Engineers and Land Surveyors in Massachusetts is the same. Sounds a little vague, or sounds like there's room for interpretation, but generally promoting truth, openness, right? Is the rest of it. Shall not reveal facts, data, or information obtained in a professional capacity without prior consent of the registrant's employer, except as authorized or required by law or regulation. What's that? Confidentiality agreement? What if those facts, like in the Morton Thiokol case, are that the O-rings are defective and no one's listening to me? If you're an engineer in Massachusetts under the code, can you reveal those? A registrant shall not permit the use of the registrant's name, a firm name, or an associate in business ventures with any person or firm with the registrant may also have reason to believe is engaging in fraudulent or dishonest or unprofessional practices. Okay, sounds pretty good. A registrant shall provide the board with any information and assistance the board may deem necessary for the investigation prosecution of complaints with the board. Okay, sounds reasonable. A registrant shall provide written notification to other registrants in the event of a substantial disagreement with the work of the other. Where appropriate, both registrants shall investigate and attempt to resolve the disagreement collaboratively. Is that what happened in Minnesota? The notified registrant is required to respond in a timely manner to the registrant giving notice. Now, I'm sure this wasn't in the Minnesota code, but here's a section that says you're required to play nice together. But then look at the last line. Have you ever seen that line before, or something like it? The registrant shall not act in a manner or engage in a practice that brings discredit on the honor or dignity of the profession of engineering and land surveying. So even Massachusetts wasn't able to resist the temptation of placing an inherently difficult, problematic phrase in their code. Yes, sir.
I think the problem, can you go back one slide?
Of course.
I think the problem's more, almost in like the very first bullet, if you like, if you back to like the Minnesota case. A registrant shall hold paramount the health, property, and welfare of the public.
Mm-hmm. Where do you want me to go?
Where you just were, actually.
Okay, sorry.
That's all right. It's responsibility one.
Yep.
So in the case of Minnesota, right, you have one person who's arguing that it's for the welfare of the people of Minnesota that we build more roads, and one person who's arguing that it's for the health and safety that we don't build more unsafe roads. And so regardless of, I think, like the last bullet, it's that's the problem, is that you can see it either way and then and fight each other over that.
I guess the point is that these codes and standards can be inherently problematic, and you need to be aware of it. You need to be aware of it.
So, is Massachusetts different from Minnesota, where you have the right to provide rebuttal or evidence? I mean, the Minnesota case seems like they would have, if they found something wrong, would have ruled independent of being given a chance to present evidence to the contrary of what the claim was and be able to defend yourself.
Well, the way it
What's
works,
the mechanism for
sure. The way it works in Massachusetts and Minnesota is the same thing. What happens is this complaint goes to one of those people that didn't pass the bar exam on the first try. And what they do is they review it and determine whether or not there's a violation of the code. It's entirely up to them. If they determine that there's a violation of the code, then what they do is they issue what's called an order to show cause, which would have gone to Charles and would have said, look, the board has found that there is a violation here. I should back up. Once the investigator finds that there's a violation, the investigator goes to the board and recommends that the board issue an order asking the engineer, telling the engineer that they must respond to the complaint. But no investigator's recommendation to a board has ever been, to my knowledge, not adopted. These boards are part-time members. They're 6, 8, 12 people. They're there to hopefully drum up some business for their engineering firms, and they sit on these committees largely as figureheads, and they delegate responsibility for all of the nuts and bolts to the people who work there, like the investigator that I was talking about. So the board will get this piece of paper from the investigator saying, I think that this engineer should be called to answer to these charges. The board puts their rubber stamp on it, it goes out in the mail. Then Charles has another letter that comes that says within 30 days you must provide a response to this complaint. Whereupon Charles comes to me, I begin the whole process of discovery with the board. I get the file, I get the information, I take depositions of the people complaining. I prepare a case, and we have a trial. Interesting enough, the trial, who does the trial take place in front of? The same people that are accusing. You don't have an independent judge, you don't have an independent hearing. The prosecutor, the judge are the same. What do you think the chances are of winning there? It's just like the Soviet system, you know? Not a lot of due process in these systems. It's Fortunately, in Massachusetts and in Minnesota, any decision, these boards are so horrendous, that any decision by a board is reviewable by a superior court judge and a jury. That's where you actually have a chance of due process.
If I can play a little devil's advocate here, I just keep seeing parallels between this and the recent like anti-vaccination cases. Because right now it's really easy for us to all get behind Charles Marone and be like, oh, well, obviously he's right, like this board is messed up. But like, what's the difference between that and then an anti-vaccination practicing doctor who, in his or her perspective, they're speaking out for the welfare of the public because your kids may get autism, like, well, that's okay, that's a different story. But like, it's while we want to keep Charles Marone in his license, how do we like actually
Balance these things?
Yeah, exactly.
Well, first of all, I don't know any anti-vaccination doctors, but if there are any, they should have the right to get out there and blog. But I imagine the AMA, the American Medical Association, the Massachusetts Board of Registration in Medicine, the Massachusetts, Association of Pediatricians, I think they may have something to say to that doctor, and you're right. And that's the thing about speech, it's the public marketplace where, it really needs to be decided. It shouldn't be stopped by official boards, and that's the point. Deal.
I think a lot of these, speaking of both from an engineering and physician side of things, a lot of these codes of conduct are written to prevent egregious, terrible behavior. So whether or not someone has a difference of opinion of practice, I think is a little bit of a overread of this code. So that's what this was talking about. He had a difference of opinion on practice that wasn't necessarily, there was a majority opinion, but it's not written in stone. If a doctor molests a patient, that's horrible. And that's really what this is going against, I think, originally, the way it was written. But they make it so vague that I think people overread it.
I agree with that. The way these are written are by committees. And what do they say about a camel? Camel was a horse designed by a committee. So you have all kinds of input when these codes are adopted, and then they later on they have to be passed by the legislature as part of the Massachusetts Code of Professional Regulations. But I think you're absolutely right. The trouble is in the application, because what happens once the well-meaning people have done their job, then people like the accuser for poor Charles comes along and decides, well, here's a wedge I can use. And sometimes, more often than I'd like to say, they're treated seriously. Anyhow, so maybe something to think about. We've already pretty much covered this, but by the way, it should not come as any surprise that there were many students who responded to Charles's blog post and said that, we support you entirely. And a lot of engineers came up and said, we support you entirely, but gee, we don't want to say anything. The veterinarian that I talked about got lots of support from all over the country from veterinarians saying, you're doing the right thing fighting these drugs in horses. Good, will you come and testify for me? Oh, no, I don't want to do that. I might, lose my license. But I think it's really great that you're out there on the forefront of this issue. And that's generally how it plays out. It's kind of lonely being out there on the point of the spear, and you'll find in your profession, there may be a point where you feel compelled by your conscience to take a position that is going to isolate you. My recommendation is to do what you think is right. Always do what you think is right. Don't follow the code. Don't be persuaded by what everybody else says. Be persuaded only by your conscience and your good judgment. All of you have a wonderful barometer for knowing what's right, and you should always follow that barometer, no matter what profession that you're in.
Where are whistleblower protections?
Well, there are very few protections for whistleblowers. There are statutes, very limited in some states. I think, maybe half the states in the United States have statutes that protect whistleblowers. But you'll find it can be very lonely for whistleblowers, and there oftentimes is no protection for them. But whistleblower statutes in general are laws that are passed by legislatures. There's a federal whistleblower statute too that tries to carve out protection for people that find they have to take positions like this. But what did the whistleblower statutes do for Edward Snowden? You know, so there's very little protection for whistleblowers out there.
This is kind of in today when you have enough communication that can happen over the internet. Do these public or these like codes of conduct for engineers, medical professionals, whatever, like even have a place anymore?
Well, you know, that's a really interesting question because these were all written back when everybody, you know, when they got mad, had to actually sit down at a typewriter or grab a soapbox and go down to the Boston Common and start. But the internet has changed all these things. One commentator said that the First Amendment, which grants free speech, and codes of conduct like this are no longer as important as they used to be. And in fact, they're considered, instead of amendments to a constitution or a code of conduct, they're considered in the grand scheme of things at most a local ordinance.
I guess, but like so. In either case, people like agree with Charles or not, right? He's a professional engineer. He designs roads. I mean, it could be anybody. Like he could design dams, right? And if his opinion is, I'm going to build dams out of toothpicks now because it's wood, it's renewable, whatever. If people agree with him, and then he builds these dams or whatever, and they explode or whatever happens, he's not going to have any business, right? And the market then decides that the free market will decide that Charles no longer can practice the engineering profession because he not necessarily violated the code of conduct, but because he was not a good engineer.
Yeah, I'm not so sure. I mean, I suppose if he suggests that dams should be built out of toothpicks, maybe the engineering profession should look into his licensing a bit. That example aside, I think that generally speaking, the marketplace should decide what speech is worth, and it's not for licensing agencies or governments to tell us. And that's, I think, the point of the whole thing. Now, oh, by the way, this is the last thing. They did find there was no violation. I want to be fair to the Minnesota Board of Professional Responsibility. They did, in this case, find that there was no violation of the code, which no one can tell what a violation consists of. But the warning that it'll be kept in his file and revisited if circumstances warrant. How does that make you feel insecure? It makes me feel insecure. If he comes into me and says, "Steve, am I out of the woods?" I say, "Nope, I don't think so. I can't tell." Anyhow, so I think we've covered it. If you're an engineer, can you engage in free speech? No. The answer is, I think, yes. If you're looking for an answer, I think the answer is yes, but it may cost you. It may cost you. And you need to be aware of that. You need to be aware of that. And you need to be ready to defend it if it's important enough. All right. I wanted to just briefly touch on the origins of free speech. I'm going to have all this stuff up on Stellar, so if you really want to get into the cases and so forth, you can. But I want to go through 5 or 6. I'm going to treat you like law students for 5 minutes. I want to go through 5 or 6 cases which really are the seminal works as far as free speech in this country is concerned. As I say, whether it's free speech or intellectual property, it all goes back to these fundamental principles. You may not think it, but when we get into intellectual property, the beginning point, the starting point for intellectual property is the United States Constitution. And same goes for speech. Beginning point for all of these state rules and regulations is the United States Constitution, which provides, under the First Amendment, Congress shall make no law abridging the freedom of speech or the press. This simple but powerful proposition is the foundation for every free expression controversy that arises in the United States. whether it involves professional engineers or anyone else. And each inevitably implicates this ever-present constitutional principle. Nevertheless, the case law which has been built upon this foundation is very complex. As I say, some commentators have looked at the First Amendment to the United States Constitution and compared to the body of law that interprets it, this is more like a local ordinance than it really is anything else, because really the devil is in the details. So here are some cases which are considered landmark in the area of free speech. One of the very first and most famous ones was penned by a fellow even engineering students may have heard of, Oliver Wendell Holmes. The name of the case is Schenck versus the United States. And it concludes that the First Amendment does not protect defendants who distributed leaflets to draft-age men, urging them to resist induction from prosecution to obstruct the draft. There were just some guys handing out leaflets, members of the Communist Party, who were trying to convince people that they should not enlist before World War I. They were arrested. They were convicted of inciting people to evade the draft. Good decision? That's the way it was in 1919, and it was written by probably our most famous jurist, Oliver Wendell Holmes. Brilliant mind. The second case I wanted to run by you is Dennis versus the United States, holding that the right to free speech guaranteed under the First Amendment of the United States Constitution did not prevent criminal prosecution if the exercise involved the creation of a plot to overthrow the government. Again, this keeps coming back to the Communist Party, but back in 1951, members of the Communist Party were essentially prosecuted for leafleting. They argued that it was their exercise of free speech, but they were prosecuted, convicted, and the Supreme Court upheld it. 1957, Yates versus the United States, Supreme Court decision holding that the First Amendment protected radical and reactionary speech. Sounds great right there. And then the caveat, unless it posed a clear and present danger. You've heard the phrase clear and present danger. Again, another limit on speech by our friends in the Supreme Court. Then Brandenburg versus Ohio came along in 1969. The Douglas Court, one of our most liberal courts, one of the courts that people say was most respectful and cognizant of the First Amendment. Brandenburg versus Ohio was a case that said that the First Amendment holding that government cannot punish inflammatory speech unless that speech is directed to inciting and is likely to incite imminent lawless action. It specifically struck down Ohio's criminal code where the statute was broadly prohibited as mere advocacy of violence in the process, overruled Whitney versus California, and essentially overruled all these other cases that we just went over. The court finally was getting to the point where they reached the conclusion that there are no appropriate limits on free speech unless it is going to imminently incite or cause violence or something terrible, like yelling fire in a crowded theater. You can't do that. But if the Communist Party wants to leaflet in front of this school and urge people to stay out of the military, they can do it today, mostly because of Brandenburg. That was a reversal for those that would restrict free speech. Reno versus the Civil Liberties Union is a landmark decision in which the court unanimously struck down an anti-indecency provision of the Communications Decency Act, one of Ronald Reagan's wonderful legislative legacy, the Communications Decency Act, which there were many people prosecuted under it because it violated this. In this case, the court concluded that it violated the First Amendment's guarantee of free speech. This was the first Supreme Court ruling on the regulation of materials distributed via the internet. And this case, which was just argued last December, and I attended the arguments in the Supreme Court on this case, This is Lonis versus the United States. The Supreme Court agreed to hear an important First Amendment challenge that will attempt to sort out, after years of ambiguity and confusion in the lower courts, when threats, specifically internet threats, should be taken seriously. This is somebody that was threatened via Facebook. The case was argued before the Supreme Court on December 1st and will hopefully clarify whether threats of violence made over Facebook and other social media should be judged by whether the threatening speaker intended to harm anyone or whether the listener was genuinely afraid of being harmed. Kind of a subjective standard, but it gets back to what we were talking about, what the court was talking about previously. There has to be an imminent appreciation of danger. Again, the court is faced with a case where they're trying to limit the prohibitions or the limitations on free speech. So anyhow, there are a few principles I think that we can deduce from this, and I just wanted to give them to you quickly. If a law gives no notice of the kind of speech which is prohibited, it is void for vagueness. A little bit like the Minnesota or Massachusetts codes, I think. If a law burdens substantially more speech than is necessary to advance a compelling state interest, it is unconstitutionally overbroad. The government may not force a person to endorse any symbol or slogan or pledge. The government restrictions on the time, place, and manner in which speech is permitted is constitutional only if they are content neutral. They leave substantial other opportunities for opposing speech, and they narrowly serve a compelling state interest. On state-owned property that does not constitute a public forum, government may restrict speech in a way that is reasonable in light of the nature and purpose of the property in question. Content-based government restrictions on speech are unconstitutional unless they advance a compelling state interest. And there are six principles, exceptions to this principle. Speech that is likely to lead to imminent lawlessness, which we just talked about. Fighting words. I'm not really sure what those are. Look at Charles Hebdo and that. Can you publish a magazine like that in the United States nowadays? A very subjective concept, and one that has not been addressed by the court. When does political satire become prohibited free speech because they constitute fighting words? Obscenity, erotic expression, child pornography, I think we all agree that those are bad things and appropriate limits. Defamatory statements may be prohibited. Does anybody know what defamation is?
Slander.
That's a form of defamation, yes. There's libel and slander. Libel is written defamatory statement. Slander is a oral defamatory statement. Steve Lyons is a child abuser. That is defamatory per se, okay? Steve Lyons is a terrible lawyer. Well, as they say, truth is an absolute defense to defamatory statements, so that's more on the borderline. Defamatory speech is permitted, but there are limits. And if it can be proved that the speech is false and harmed a person, there can be civil liability. So while you can practically say anything you want, you may have to be accountable for it. And that's the balance that the court has struck when it comes to that type of speech. And finally, commercial speech may be banned only if it is misleading, pertains to a legal product, or directly advances a substantial state interest with a degree of suppression no greater than is reasonably necessary. Great words, lawyer-type words, but what it means is commercial speech is generally, you can say anything you want. My laundry detergent is the best laundry detergent in the world, protected by the First Amendment of the United States Constitution. Anyhow, conclusions. This is the class discussion part. Can you be an engineer and speak up for reform? What are the rights and responsibilities of scientists engaged in the public dialogue around science-based decisions? Should an engineer have their professional credentials questioned or threatened simply for speaking out for reform in the area they work? Is there a chilling effect on speech? And do scientists give up their First Amendment rights at the laboratory door? I hope that this little talk today has caused you to think about some of those things. And next week we're going to get into your favorite, intellectual property. I have, to be brutally honest, evaluations. If you just take 1 minute and fill them out for me,